day, everybody. It's Michael Leveris from JurisQ, where we answer your frequently asked questions on law. And today we're back with Matthew Sullivan, a law partner in the law office of Gregory, Spektor and Associates, a personal injury firm. Matthew, we're so pleased to have you back with us. Thank you.
Thank you for having me. It's always a pleasure.
Thank you. And Matthew, we talked at our previous sessions about scaffold law, where there's really no defense against a worker falling from a scaffolding, or if something fell on the worker from some height, the site owner, the contractor, will most likely be liable for the injuries. And I want to follow up with an interesting scenario. Scaffold law or any other construction accident injury, it happens sometimes where a worker is found to be either intoxicated or maybe under influence of drugs at work, and an injury occurs. First of all, I'm sure it happens. I'm sure you've seen it. What kind of scenarios can they be? Can the injured, intoxicated worker still get compensation for his injuries, or maybe it's going to be less of a compensation? How does that all play out?
Although we don't encourage it, the injured, intoxicated worker can absolutely be compensated for their injuries.
Okay.
And that, again, is governed by the principles we discussed earlier with the New York State Scaffold Law and Labor Law 240. Looking at a case that involves those facts, where someone falls from a height, for example. I had experience in a case where a worker fell from an I-beam. He was carrying a plank of wood across an I-beam. Gosh, it had to be about approximately 20 feet high. Wind came, blew him and the plank off of the I-beam.
Right.
He fell. It's really a miracle that he survived.
Sure.
When the ambulance arrived, someone in the ambulance saw symptoms consistent with cocaine use and administered Narcan at the scene and eventually treated him for cocaine in his blood. Michael, we discussed earlier that there are only two defenses to Labor Law 240, the New York State Scaffold Law: sole proximate cause and recalcitrant worker. So there was this bad fact in the middle of the case that injured worker had cocaine in his blood.
And I'm sure defense, the insurance company, made a big deal out of it, right?
They absolutely made a big deal. Unfortunately for them, fortunately for the injured worker, they couldn't connect that to the accident being 100% his fault. At the end of the day, this worker was exposed to an unprotected fall area of approximately 20 feet. The wind blew him off. He wasn't provided with a proper harness, a proper or other safety device. And so it was found that that was a violation of Labor Law 240. Once found that there was a violation, from a liability perspective, the defense couldn't really talk about the presence of cocaine anymore.
Interesting.
If we can contrast that, Michael, with a statute, Labor Law 241-6, where fault is a defense, then it gets a little trickier for that intoxicated worker. Then it's an easier argument to say, well, there was cocaine in his blood. Did that contribute perhaps to how the accident happened? Did that contribute to how this individual used a particular tool under that portion of the statute? Or did that contribute, if he tripped, to his imbalance? Then you're talking about a different scenario.
I see.
But going back to your original question, can an intoxicated worker recover for their injuries? The answer is certainly if there's a violation of Labor Law 240, and potentially if you've got to look under the other statutes of the New York State Labor Law.
Let me ask you, but let's say the court finds, yes, the worker deserves compensation, but the fact that he or she were drunk, it is some kind of factor to consider. So maybe, is it possible the court would have, or jury would avert would award that person less than 100% of a verdict of an award and say, you know what, you're responsible 20% of your injuries because you did show up to work drunk.
Under the New York State scaffold law, remember, comparative fault isn't a defense.
Got it.
So in that scenario, the facts you described, it wouldn't play out that way. Mm-hmm. But answering your question, if we were to look under different portions of the New York State labor law where you could consider comparative fault, right, then absolutely a jury very well could determine that a worker's intoxication amounted to, let's say, a 25% offset of comparative fault. And that's exactly how it works. If the jury said the worker was 25% at fault and then awarded him or her a verdict of $1 million, mm-hmm, that number would automatically be reduced by 25%.
Got it. Interesting. Okay, Matthew, the lesson here is even if you were intoxicated at work and you got injured, you still have a very big chance of recovery. So go to your attorney, but don't go to your attorney drunk.
Thank you.
We want an informed, educated client who has full control of his or her senses. So that being said, the phone number of Matthew Sullivan, who is a premier construction excellence attorney, a partner in the law office of Gregory, Spektor & Associates, a personal injury firm. The phone number is on the bottom of the screen. If you were injured for any kind of injury or incident at a construction site, at a work site, don't hesitate. Call the phone number and you're going to get free consultation. And I'm sure the attorneys will be able to tell you the chances of recovery for your injury. Matthew Sullivan, thank you so much. It was a pleasure having you back. And I hope to have you soon on more sessions about personal injury law and construction excellence. Thank you, everybody, for tuning in. Until next time, have a great day.
Thank you.
Thank you.